We will now discuss software patents. So what is software patenting? Software patenting involves obtaining legal protection for innovative software-related inventions. A software patent grants the holder exclusive rights to use, make, sell, or license the patented software invention for a specified period. In the US, it's 20 years from filing. We will now discuss the historical context and evolution of software patenting. So, in the early days, in the early years of computing, software was generally protected under copyright and not under the patent system, as it was considered more akin to mathematical algorithms, which were not patent eligible. Now that changed in 1981 in the Diamond v. Diehr case, where the U.S. Supreme Court established that software implementing a mathematical formula could be patentable if it produced a practical application. This decision marked a turning point for software patent eligibility. In states, in 1998 and in 2010, the court decided the State Street case and the Bilski case. In State Street Bank and Trust Company versus Signature Financial Group, and later the Bilski versus Kapos case, the courts clarified the patentability of the business methods, including software. So as long as they can meet specific criteria, such as being tied to a particular machine or transforming an article, they are patentable. However, in the case of Alice versus CLS Bank in 2014, the Supreme Court imposed stricter guidelines, stating that the abstract ideas implemented on a generic computer were not eligible for patent protection. This decision has significantly impacted the patentability of certain software inventions. However, there are still ways to protect software-related inventions if you can establish that it improves machine performance or transform the utility of the result. So more recently, the USPTO has provided guidelines to determine eligibility of software patent applications. So what are the key challenges for doing a software patent? So first of all, you have to establish subject matter eligibility. Determining what constitutes patent eligible subject matter for software invention, especially in the context of abstract ideas, remains a challenge. The distinction between abstract ideas and concrete practical applications can be subjective, and however, with the proper legal assistance, you can make a case for software patenting of your software invention. So another challenge in software patenting is the rapid technological changes. The fast-paced nature of the software industry makes it challenging for the patent system to keep up with evolving technologies. This leads to concerns about the relevance and adequacy of patent protection. However, this can be solved with a skilled practitioner who can use the accelerated examination program, and also in claiming, so that you minimize the number of trips back and forth to the patent office. So the takeaway here is that to enhance the chances of obtaining a software patent application, you need to emphasize the specificity of the software invention and its practical applications rather than the abstract concepts of doing something using a computer. The other thing to focus on is how your invention accelerates computer performance. So that's a way to get out of this abstract, the Alice rejection. So the other thing is to file more applications, given that the enforcement of software has been spotty. Roughly, I think more than half of the patent litigations involving software patent has turned out in a negative. So So what you should do is to file higher quality patent applications and do more of that. And this is easy to do given continuous innovation techniques, right? Given the evolving legal landscape and rapid technological changes, what you do is you just file more cases, and this can be done cost effectively using software such as Power Patent, which can create a first draft in about 10-15 minutes. And then, of course, a professional can then come in and clean it up. So because of the legal challenges involving software patents, you need to engage with IP attorneys who specialize in software patenting to navigate the complexities of software patent space. And so in short, software patenting is a dynamic and evolving area requiring vigilance, adaptability, and a nuanced understanding of legal and technological landscapes. Next, we will talk about patent search. In general, we recommend that you do a patent search before you start the process of patenting because it's an expensive process. So it makes sense for you to at least do a sanity search to verify that your invention is novel. So part of the difficulty in doing the patent search is how do you search for novel aspects? Initially, you're going to have to come up with an angle on, let's say, what are the minimum features of your invention that you think to be novel. And so what you would do is then go to a search engine, such as the engines available at the US Patent Trademark Office or at the European patent offices. You can also use Google Patent Search, although there are some people who fear that providing that input into a public search engine means exposing the idea to Google, for example. So in general, you can use, there's a number of search engines that you can use for free. So that's one option. The other option is, if you want, is you can always hire a firm to do a search for you. In a professional search report, they will normally pinpoint. Let's say if you claim novelty, the novelty is they include A, B, C, and D. The search will then pinpoint, where in the references would they show A and B and C and D, and so they may combine 2 or 3 references to show all of the novel elements of your inventions, or it may, and that's called obviousness. The invention is obvious, or they can show everything into one single reference, and that's a novelty. You lack novelty if everything exists in one reference. So in general, we recommend that you, if you're writing a provisional application, just do a sanity search, and then you can use that information to train, to write your application and focus on what is the novelty and how it differentiates from the prior art. And in cases where it's a make or break of the company, and when you think that the patent is so important, then it makes sense to utilize a professional search firm who can search international documents. They can search non-patent document as well. And so that's the way we recommend it is for most inventions, you just do a sanity check on your own. For important applications, you should consider use a professional search firm. Now let's talk about key considerations in software patenting. First, subject matter eligibility is very important. So the eligibility of software patent often hinges on avoiding the characterization of the invention as an abstract idea. As stated earlier in the Alice case, the Supreme Court established a 2-part test. A, is a claim directed at an abstract idea? And B, does the claim include an inventive concept that transforms the abstract idea into something significantly more than just the abstract idea? So your strategy is to clearly articulate how the software solves a practical problem or improves a technological process. The application should emphasize specific and tangible applications, as well as how it improves system performance or system output. So for example, if your software improves compression by a certain percentage, then that should be brought out as part of the specific and tangible application. How do you circumvent the abstract rejection? As discussed earlier, you should highlight any technological improvements or innovations achieved by the software. Demonstrating how the software addresses technical challenges or enhances computer functionality strengthens the case for patent eligibility. That's why you should have a standard paragraph in your application describing how it improves processing speed, processing performance of the computer, or how the output, the result is improved. You should provide a detailed description and a comprehensive description in the patent application that clearly outlines the technical components, the processes, the functions involved. And if you have this in the application, it minimizes the risk of the abstract characterization. Of course, avoiding the abstract rejection is only part of the work. You still need to show that the invention is novel and non-obvious. So overcoming rejections based on anticipation or obviousness can be challenging due to the vast amount of prior art in the software domain. So how do you handle this? One way to do that is a prior art search to identify and address potential challenges. This involves not just searching existing patents, but also technical literature, open source projects such as those at GitHub, and other publicly available information. Additionally, your claims should be very specific. You should craft claims using precise languages to clearly distinguish the software invention from the prior art. The claim should highlight unique features, algorithms, or methods that sets the invention apart. You should also discuss in the description specific and substantial utility. Clearly define the specific utility or practical application of the software. Show how it provides tangible benefits or solves real-world problems. Avoid vague or overly broad utility claims. You can also provide a use case scenario or example in the patent application that demonstrates how the software is applied in practical settings. This strengthens the argument for utility. You should ensure that the software is described in a manner that enables a person skilled in the art to understand and reproduce its functionality. Clarity and operability contributes to demonstrating substantial utility. You may want to consider putting in a section of the code or the data structure that is important in your particular invention. So, in summary, successfully obtaining a software patent involves presenting the invention in a way that aligns with the patent eligibility criteria, emphasizing concrete applications, technological improvements, and specific utility while navigating the evolving legal landscape contributes to building a robust and defensible software patent portfolio. Regular collaboration with legal experts with software knowledge ensures strategic and informed decision-making throughout the patenting process. Next, we will discuss the process of obtaining a patent. So, as an overview, the process begins with the idea, the conception of the idea by the inventors, through filing for the patent protection, and then you go through examination, and then eventually the patent is granted. So what do we need for filing the patent application? After you've ideated the concept, then you need to generate documentations about how the invention works. So the documentation can be a number of forms, such as a Word document, or a series of drawings, and the combination of which provide a very detailed description of how the invention operates. After we have that, then we can discuss what type of patent applications to file. You can have provisional patent application, you can have non-provisionals, or you can directly file international applications. So a provisional is a temporary application that lasts within a year that must be converted to a non-provisional. The non-provisional application is the one that's actually examined, and that's when you will get some pushback from examiners as to your novelty or your obviousness. The PCT application is for companies that are well funded that is interested in seeking international coverage. And the PCT application can be done either upfront or can be done within 12 months of the first application file. And if you do that within the 12-month basis, you can claim the priority date, stretching back to that 1 year. And so PCT is a useful mechanism to defer some of the international expenses because it delays the international filing date up to 30 months from the first filing date. So you can wait to file internationally up to 30 months and still can get the priority date of your first file application. If you have questions, just text me on that. So once you file a non-provisional patent application, it goes into a queue where other applications have gone into, and eventually you'll exit the queue for examination. That transit time is approximately 18 months to about 2 years. And the examiners will pick up your case, and generally what they'll do is they're going to do a patent search, and they're going to try to push back on you if they find relevant prior art that indicates either the identical invention has been done already, or if they can point to 2 or 3 other patents in combination make up your invention. And they'll say that that invention is obvious in light of these 2 or 3 prior patents. So then you need to argue with the examiner as to why the combination of references may not be correct. And if you're successful, the examiner will send you a notice of allowance, and then upon paying the filing fee, it becomes a patent. So once you have a patent, then you have exclusivity for that concept for the life of the patent, which is around, in the US, 20 years from the filing date. Every 4 years, there is a post-grant process where you have to pay a maintenance fee, and if you don't pay the maintenance fee, then the patent lapses. So in general, because this is a complicated process, we recommend that you use the services of a lawyer, or if you want to save money, use software that guides you through the process of writing the application so that you can write a document as completely as possible on your own writing time. And then you can take that document to a professional, such as a lawyer, and seek professional assistance in filing it. We think that approach is the best way to save money because you know the domain of your technology and you can utilize a software that guides you into this process. And once you have all the documentation in place, the lawyer can use her expertise to refine the claims and to improve the quality of the application to maximize its chances of success. So we recommend that you, the first time you've done it, then use some sort of a software to document your application. And then you take that to a professional and request a discount. And this process will save you money, save you time, and improve the overall quality because you are now collaborating with the lawyer to improve the quality of your application. After obtaining a medical device patent, there are several post-grant activities that you may need to undertake to maximize the value and protection of your intellectual property. Here are a few post-grant activities for your patents. First, maintenance fees. Mark this on your calendar to regularly pay maintenance fees every 4 years to keep the medical device patent enforced in the US. Internationally, annuities may be due on an annual basis. And so the failure to pay these fees can result in patent expiration. The other activities include surveilling the market. So you need to monitor the market for potential infringement. Your salespeople can keep a vigilant eye on competitors to see if they are using similar technology or products that your patent covers. You need to stay informed about the activities of the competitors, and this includes tracking their new product releases, their patent filings, and any legal actions relating to patents. You should continuously assess the overall patent portfolio and consider filing additional patents for improvements, new features, or related technologies that may arise in the development of new versions of your medical device. You should also explore licensing activities. The licensing agreements can generate revenue through royalties and expand the reach of your innovation. You should consider expanding the geographical coverage of your patent protection by filing for patents in the key jurisdictions. This is important for global market penetration. Of course, you should be keeping an eye on technology. Stay abreast of technological advancements in your field. This awareness can identify opportunities for further innovations and potential adjustments to your patent strategy. So by actively managing the post-grant phase, patent holders can maximize the patent investment and leverage the patents for business growth, collaborations, as well as for maintaining a competitive advantage in the space. Regular assessments and strategic decision making are crucial in navigating the evolving landscape of medical device patents. And we hope this will give you thoughts on how to implement your patent strategy. Thank you for joining our intellectual property education series. We hope that this journey has empowered you with the knowledge to navigate the world of patents, trademarks, trade secrets, and copyrights. Stay inspired, protect your innovations, and continue to explore the boundless possibilities of your inventive mind through the intellectual property system. Subscribe for more insights, and until next time, innovate boldly.